Hey everybody, thanks for being with us today and welcome to the virtual campus of the University of Texas. I'm Professor Bobby Chesney. I'm the director of the Robert Strauss Center for International Security and Law here at UT. The Strauss Center has a lot of programs, including a cybersecurity program, but the program affiliated with this event is better described as our Brumley Graduate Fellows Program, which is one of my favorite things we do, where we have a highly competitive selection process and get students from grad schools and grad programs across the university to become part of our operations, including, among other things, matching them with faculty from units outside their own, supporting them in their research, and supporting them when they identify an outside scholar or policy figure that they would love to meet, love to have come speak to the community. And today is one of those occasions. So let me introduce to you one of the Strauss Center's all-time favorites, Claire Hewitt. Claire's been with us for a number of years because she's getting both a law degree and a master's in global policy studies, so a joint degree candidate, and has been a mainstay in our cybersecurity courses, among other things. She's a shining example of the talent we have here at UT, and we're going to miss her next year when she goes off to practice law at Norton Rose Fulbright in their DC office. Claire's previously worked for the State Department at US Embassy Tokyo. I believe she worked at DOJ at the International Affairs Office. And so I think all these topics come together in the presentation that we're going to be hearing shortly. But first, let me turn it over to Claire. Claire, the floor is yours.
Thank you so much, Professor Chesney. I will definitely be missing the Strauss Center next year as I go off, but I'm excited to stay involved for the rest of my life with UT and this group. I'm so excited to be introducing Dr. Catherine Lotrionte today. She's currently a senior researcher at Georgetown University, a senior associate in the technology policy program at CSIS, and a senior fellow at the McCrary Institute for Cyber and Critical Infrastructure Security at Auburn University. Previously, she served as the Brent Scowcroft Scholar at the Atlantic Council. She's also the founder and former director of the CyberProject at Georgetown University, where she's taught and written on international and national security law and international affairs and technology. At Georgetown, she founded CyberProject in 2008, and the annual international conference on cyber engagement as well, which draws on the experience of government practitioners, industry representatives, and academic scholars, and it provides technical, corporate, legal, and policy perspectives from the international community. Lotrionte served as the counsel to the President's Foreign Intelligence Advisory Board at the White House on the Joint Inquiry Committee for the Senate Select Committee on Intelligence, investigating the 9/11 terrorist attacks, and as an assistant general counsel at the CIA and in the US Department of Justice. She's internationally recognized as an expert on international law and cyber conflicts. She's testified before Congress and NATO on cyber issues. And we're so excited to have her here today. So thank you so much, Dr. Lotrionte, for joining us. And for everyone who's participating today, please feel free to write up your questions and send them in the chat, because at the end we will have a pretty robust Q&A, and we're really looking forward to hearing your remarks.
Thank you, Claire. Thank you everyone for having me today. I'm really hoping that we have some good questions. I get quite tired of just hearing myself talk. I teach enough, and most of the time I'm talking at my students in my lectures. So hopefully while I'm talking, you guys can think of some good questions, and Claire has promised me she'll give me some warnings, so I leave plenty of time for the Q&A. So first, a little background to explain kind of, you may have, I think what maybe prompted the request to have me come and talk to you about economic espionage is an article that I wrote in the North Carolina's Journal of International Law and Commercial Regulation. That article came out in 2015. To give some background as to why I wrote that article, kind of why I was focused on economic espionage at the time, it'll be useful to just mention two things. In May of 2014, the Department of Justice had indicted 5 members of the People's Liberation Army, PLA, of China. This indictment and the charges were for computer hacking and economic espionage. This was the first time that there were criminal charges against a known state actor for hacking. So it was pretty significant. And so at the time, I took note of that and began thinking about the issue of, well, what is changing when it comes to particularly cyber espionage, and specifically what I usually term as economic espionage, and how that might be different from the traditional political military espionage. And so I started writing a short paper that was meant to be the basis for a workshop that was going to be taking place in Paris. And it was going to be mainly governments, but also academic representation. And it was the French delegation that asked me to lay out what I thought was the US government's policy perspective and the distinction that the US has traditionally made between economic espionage and political military espionage. So this is how the basis of the Law Journal article began, was because I was using it for a kind of, I guess, a white paper of sorts for this workshop. Now, while I was writing this article, it took me quite a bit of time to kind of get it out. It was published in the winter of 2015, but in September, it's not mentioned in the article, but in September of 2015, another event happened, it was significant in that it was the first time that it was President Obama and President Xi came to an agreement. And in that agreement, there were a number of elements dealing with cyber activities, but one specifically relevant to our conversation today was in that agreement, they agreed that they wouldn't be sponsoring or knowingly be a part of what they termed cyber-enabled theft of intellectual property. So there has been much discussion since that agreement in September of 2015 as to whether China has complied with that agreement. But we can put that aside for now. I wanted to just mention those two events that, particularly the indictment that really started getting me thinking about writing something, and then a workshop that caused me to sit down and actually put my thoughts together on this. Now, you may or may not have had a chance to even see the journal article, and I wouldn't be surprised if you didn't even get through, even if you looked at the title. It's quite long, and honestly, it took me about a year to write. It wasn't the only thing I was doing, but still, that was a long time for me to write a law review article, a law journal article. So it's pretty dense. So I wanted to kick off the conversation with kind of the big picture of what the article was about, what I was trying to do. So I gave you a little bit of background on what brought me to it. Now, what's important is definitions. Typically, lawyers kind of make a lot to do about definitions, and that becomes important. And in the article, but also in my work in the government, there has traditionally been a difference and definitionally and operationally between what is called economic espionage and what is in the article, I talk about economic intelligence. Now, economic espionage is typically described as a state using its national intelligence resources and assets in order to steal information from the private sector of another country. But the important distinction that will be important, and you'll see in a minute, is that they're using that information not necessarily to enhance their national security policy making, but to actually provide a benefit to their own private sector companies within their country. Now, that is in the article in what I discuss as economic espionage. Now, traditional political military espionage also involves a country using its national intelligence resources and assets to steal, collect intelligence information from abroad, whether targeting individuals, governments, government officials, it could be terrorist organizations. And that information is used to enhance the government's foreign policy making. Right? So traditionally, it's done in a clandestine manner, and sometimes it's called, intelligence collection. But that's what, when we refer to political military espionage, that is what we're talking about. Now, within that category, there is economic information that is often collected by a state's intelligence services that is used to benefit that state's policy making. So it could be the examples I give in the article, it could be economic information with respect to currency valuation, or it could be about trade negotiations. But the purpose and the use of that is to go back to the country in order to inform their national security apparatus or foreign policy making bureaucracy. It is not used in order to benefit the private companies to get a competitive edge against competitors globally. Now, the United States, and this is what the French had asked me, because they really weren't quite sure about the history of why the United States claims to make a distinction between what it does in the realm of political military espionage, meaning using our intelligence services to collect information that's not publicly available from abroad and using it in our policymaking process or our national security bureaucracy. And the distinction that the US draws between that and the economic espionage, which is you're using your intelligence apparatus to collect private information. Typically what we're talking about, what I talk about in the article, is intellectual property from other countries' companies. And your intent is to use that to provide it to your own companies to give them an advantage in the global economic trading community. So the US has traditionally, and in the article, I try to go over the history of this because the French had said, well, we're not quite understanding what the distinction is. Other countries don't necessarily draw that distinction, and China historically has not drawn that distinction. So the US historically, and this goes back to before we had the internet, so we're not talking about just the cyber-enabled economic espionage, but in the physical realm, if you will, in the 90s, we saw that there was quite a lot of discussion, some of it which became public because there were studies done, where the US was concerned that even our allies were conducting economic espionage against our private companies in order to benefit their private sector. And so the US intelligence community actually looked at this issue. There was a debate whether the US should get in the business of doing this also in order to level the playing field, as they were discussed. Ultimately, it was decided that the US was not going to be doing this, and particularly the focus was on the intelligence community because they had the capabilities to do this. The thought was that it would be the intelligence community that would be asked to do this. And so it was decided, and there was a 1990 or 1991 report or study that was put out and is publicly available now by the CIA, saying, in fact, the agency didn't think that it was going to be appropriate for an intelligence agency to actually do this work. So it's certainly been in line with US government practice that there's this distinction that's made between collecting intelligence, foreign intelligence collection for national security purposes versus foreign intelligence collection targeting private entities, but to benefit your own private companies. So in the article, I spent some time talking about that distinction before I then began to talk about international law. Now, the reason why I began to think about the international legal aspect of the issue was before the indictments in 2015 of the 5 PLA members. There was a concern, and there continues to be a concern in the United States, that the level of the, if you will, cyber-enabled IP theft is getting to a point where, and the economic figures for damage vary, but even if you take a conservative, what some of the conservative estimates, you're talking about hundreds of billions of dollars of damage done to the US economy because of this cyber-enabled IP theft. And so it became a point of much concern within the US government. And as I began looking at this, a question was raised as to what could the United States do, aside from kind of diplomatic negotiations and agreements like the Obama-Xi agreement. Were there other levers under international law, other steps that the US as a target or a victim of this activity could actually do in response? So that's where, and in most of the time in the article, most of the time I spend on looking at customary international law and the rule on non-intervention. And so, just briefly, I don't know, hopefully we can get into more refined questions and we can dig into the elements of the rule on non-intervention. But just briefly, in international law, they're part of customary international law. That's actually this rule, if you will, has been around prior to the UN Charter, but it continues after the UN Charter went into force. It's widely accepted as binding universal customary law. And this rule, in a nutshell, says that states are prevented from interfering or prohibited from interfering in the internal or external affairs of a state on the issues that are reserved for the state to decide on its own. So any topic or any issue that international law does not regulate and leaves up to the state to decide on its own. Typically, the examples are like political issues, economic issues, cultural issues. It could be social issues. These issues are, in the language of international law, considered part of the domain reservé of the state. And the state is to be free to make these decisions without any outside intervention into those areas. Now, that's one part of the test, if you will, for the rule. The second part, and I would say the second part is probably the most controversial in that some people disagree about the nature of what coercion means. And in order for this activity to be a violation of this rule, it not only has to intervene into one of these areas of domain reservé where the state has the free authority to decide independently from any outside interference, but it also has to be a coercive act that the alleged perpetrator or violator, the alleged state is doing. So it's got the disagreement, I would say, debate is about what coercive means. And in other words, what threshold of activity do you need in order to find that a state has actually conducted a wrongful intervention? Now, what we do know from the International Court of Justice, and particularly the Nicaragua case, is probably the clearest that we have under international law, is that we do know that for an act to be violative of this rule, it's got to be more than just interfering. It's got to be, and that's where the coercive element comes in. We also know from the Nicaragua case that uses of force are always considered also, uses of force as prohibited under the UN Charter, Article 2.4, are always considered to be interventions, but not all prohibited interventions are uses of force. So it's only the most, if you will, egregious of the interventions. So you can have non-forcible interventions that are coercive in an area where the states has a freedom to decide on its own, which amount to a violation of this rule. So what I did in the article was I took this customary rule, I looked at it, and I tried to, based upon the precedents and state practice, see if there was anything within the rule and how it's been understood by states over time that would be relevant to looking at the cyber-enabled IP theft, and whether cyber-enabled IP theft conducted by a state against another state, and stealing the private company intellectual property of private companies that have the state to be used for its own state private sector benefits, if this could trigger or amount to a prohibited intervention. And so I go through the steps. Now, my own conclusion is that it could. I would say not everyone necessarily agrees, but it does come down to the aspect of coercion. If you believe that the test of coercion has been met, surely deciding kind of your economic policy and engaging on the international global market will be part of what's considered a domain reservé or an issue of which the state can decide freely without interference. So it all comes down to, on the threshold of coercion, if you are stealing, and where I draw the line is that I basically say that if you're effectively blocking a state from being able to be competitive economically on the global market, you've effectively, it meets the criteria of a coercive act. You've prevented a state, because of the massive IP theft, from actually conducting their international economic relations or even domestic policy related to that, the economic international market, if you will. So in the whole purpose of me looking at this, though, was under international law, if a state has actually suffered a breach of an obligation, and arguably if you violated the rule on intervention, then the target state or the victim state, in this case, I was thinking the US, we're thinking about the cases that were mounting up that China was conducting against the US, what could the US lawfully do in response, aside from kind of the diplomatic options? And that's where, in that second half of the article, I looked at the law of countermeasures under the law of state responsibility. Once again, part of customary international law. And since 2001, the international lawyers have quite a bit of, if you will, data or analysis to kind of read and think about and to apply, because the International Law Commission came up with their final draft. It's no longer a draft, but the final articles on state responsibility. And within those articles, they deal with the law of countermeasures. So that was like, I think it was at least 20 years in the making. But they laid out both the procedural and substantive requirements for conducting countermeasures. And this is where I thought it fit into the US's concern. What measures could the US take in response to arguably an unlawful intervention with the cyber-enabled IP theft? And what I talked about in the article was you would look at the law of countermeasures and what would be allowed within countermeasures. Now, countermeasures come with quite an extensive list of, as I mentioned, procedural and substantive requirements. It is not something that to be taken lightly. There are very strict rules, procedural rules in place from which that you have to follow in order for it to be a lawful countermeasure. For instance, they cannot be forcible, meaning they cannot violate Article 2.4 of the UN Charter. Typically, there's a preference, although not a requirement, that you give notice if you're going to conduct a countermeasure so that other state can actually become compliant. So if you conducted a countermeasure without any, if you will, justification, you would be doing something illegal. So that's why it falls under the if you will, secondary rules on state responsibility. It's kind of the countermeasures, as well as other justifications for wrongful action, kind of exempts you from any wrongful act yourself. So in conducting the countermeasure, as long as you follow the procedures of countermeasures, your action would be precluded from being wrongful, if you will. It's not, doesn't make it legal, but it is, in some words, it's justified. So, and I can go into details about what the rules are with respect to countermeasures, but generally speaking, if you think about it, if a state suffers a breach of an obligation owed to it under international law, now that can be based on treaty, or in this case, what I'm talking about is customary obligation, that you won't intervene in a state's affairs. If a state suffers that breach, then the obligation is upon the breaching state to come to a point of complying with its obligation. And the victim or target state can actually conduct countermeasures in order to get that offending state to become compliant in its obligations. So once it stops conducting, in this case, the intervention, arguably your right to countermeasures ends. Now, there's some debate as to how long that right can continue, particularly because you also have the right to have reparations paid, and if you can continue your countermeasures until those reparations are paid. But there is some debate on that. But generally speaking, that's kind of what countermeasures are about. Now, in the article, I also talk about, because I was asked to, originally when I was writing this for the workshop, I was only going to deal with customary law and the rule of non-intervention. But because there were quite a few trade lawyers, and I don't teach on international trade law, but because the workshop was going to entail some discussions about the WTO and the possibility of the US bringing a claim in the WTO against China for some of these cyber-enabled IP theft, they asked, okay, would you kind of talk about at least your thoughts on whether the WTO would be an effective regime for recourse for the US when it comes to the cyber-enabled IP theft? And so in the article, I also review the WTO, specifically the TRIPS agreement, which has a provision for the protection of intellectual property. It's basically the most comprehensive, if you will, international agreement on protection of intellectual property. But as I outline in the article, there are a number of challenges, if you will, and difficulties with using the WTO if you're trying to seek recourse, specifically for cyber-enabled IP theft, or what is generally called economic espionage. So although I don't rule it out, I do highlight in the article the number of challenges. My emphasis is on the customary law and the rule of non-intervention overall in the article. Now, that's a general take, a general view of the journal article, and also in general economic espionage. I want to ask Claire, because Claire also mentioned that you all might be interested in discussion of some of the negotiations going on with cyber norms at the UN and otherwise, and how it relates to even international law. But Claire, I wanted to check first with you as to how many minutes before Q&A starts?
You've got about 10 minutes. I was just about to jump in.
Okay. So Claire, do you think it's okay if you think it'd be useful to give an overview of the UNGG efforts and the negotiation on the norms?
Yeah, absolutely.
Okay. So putting aside economic espionage for a minute, and I know that's kind of the topic, and hopefully we'll get into some questions on that. When I was speaking with Claire earlier, she thought this might be interesting also to talk with you. Probably since about 2010, I became more involved, or let's say first academically interested, and then more involved where I was part of some of the participation within the group of governmental experts in the UN. Back it up a little bit to tell you about the history. In 1998, for the first time at the UN, and generally in international kind of relations or law, the first time the Russians tabled a resolution at the UN. And what they were requesting or tabling was that we negotiate a treaty that would, in effect, prohibit cyber warfare. So this was 1998. Now, at the time, the US, and I remember this very clearly because at the time I was working at CIA in the General Counsel's office, and I thought it was really interesting. I was teaching international law then. I was interested in the US's response to that. I was curious to see if any states actually took it at that time seriously. Now, not too surprisingly to me, the US, as well as allies, paid no attention to it. In fact, kind of thought it was a little ridiculous that the Russians thought that we would sit down and negotiate this treaty that would be prohibiting these cyber weapons, especially given the most recent history on the chemical and biological weapons convention, where we, I don't know, maybe 10 years earlier had come to the final conclusion where we had enough evidence to know for certain that the Russians had been cheating on those conventions, right? The chemical and biological weapons. So it was for an area where to be able to verify compliance is, I don't know, not completely impossible, but in 1998 was thought to be virtually impossible. There was no real effort to sit down and negotiate such a treaty. Interestingly enough, the Russians, since 1998, all the way up to today, are at least consistent in what they believe is necessary in this space to regulate state behavior. They're still calling for a new treaty for cyberspace. But since 1998, and it really started in 2004, the UN, the Secretary General said we need to start, paraphrasing, we need to start looking at the threats that are posed by the UN called international ICTs, international communications technology. ICTs, in a nutshell, kind of it's cyberspace, where US diplomats and people would refer to it as, the internet. And since 2004, they've had groups of experts, government representatives coming into these groups, typically 15 and then 25 members represented, always the permanent members of the Security Council, which is interesting because you have China and US and Russia, three very powerful cyber powers, always within these negotiations. And so over the years, you can see how these different states have come down on certain positions with respect to cyber threats, but also I would chart it as starting in 2010. Starting in 2010, there was a focus on international law and the applicability of international law to cyberspace. In 2013, it was the first time the group came up with a consensus report saying that the international law in general applies to cyberspace. I mean, it's funny because I was teaching that for a number of years beforehand. Once in a while, I had students saying, well, why do you assume that international law and the UN Charter even applies in this space? Because there is no specific treaty. And I had always taken it as, well, it was kind of course, it's not that there'd be no law. That's how international law would develop. But in 2010, really in 2013, at least the UNGG members agreed, including the 5P, that international law applies. So it kind of resolved that question. In 2013 and 15, they continued to reaffirm that agreement. By 2017, things got more challenging because the US's position with our allies, of the like-minded they're called, wanted to get into more specific details, not just that international law applies, but talk specifically in the consensus reports about how international law applies and specifically what principles of international law, even outside of the UN Charter, might apply. Big areas of disagreement. 2017, they did not come up with a consensus report because they disagreed on three specific areas of international law's applicability for cyber. First was self-defense. Russians were very persistent. Starting, I would say, you started to see them, even when they were agreeing that the UN Charter applied, they were saying at the same time, oh, but self-defense. There is no such thing as the right of self-defense in cyberspace. My view was that's interesting because Article 51 of the UN Charter incorporates, the customary right of the inherent right of self-defense. But so by 2017, it became clear that not only the Russians, but the Chinese, by then also the Cubans that were now members of the group, they were going to insist that self-defense was not a right recognized in cyber, as well as the law of countermeasures and the international humanitarian law, which became a big deal. The laws of armed conflict would be very important, at least the US's position, as well as other countries, to have them applicable in cyber in the context of any kind of conflict that involves cyber operations. So fast forward, so 2017 was the last attempt at getting a report. They didn't get it. There's a new UNGGE now that's actually currently going on. They will hopefully come up with a consensus report. There's some, question as to whether they'll get agreement. But in the meantime, there's been another process, a parallel process that the Russians promoted and proposed at the UN General Assembly. It was accepted in a resolution. The US did not like it, did not support it, but it was accepted. And that was a new group that was created, established in I think it was the end of 2018, was operational in 2019. And they just came out with their first final substantive report. And that group is called the Open-Ended Working Group, OEWG. That group, interestingly, is any member of the UN can be part of that group. So much more participation. The idea was some states like Russia, China, they alleged that the UNGGE process was too insulated with only 15 and then 25 members. That still kept quite a few states out of the loop and not part of the discussions. And so now it's open to all states that are interested. And so there's if you read what's interesting in their final report, unfortunately, with respect to the law, if you care to look at it to find any more progress on agreement on the applicability of international law within the open-ended working group, you're not going to find that. I think the report's on the UN website. I'd highly recommend if you're interested in it to look at it. I believe it was March that it was officially released, maybe March 12th. And what's interesting is, so the report, the only thing the report does with respect to the law, the legal part, because it does do some really useful other kind of progressive ideas on confidence building measures and capacity building. But in terms of international law, which is kind of my focus, the only thing it says is that it goes back all the way to the exact language of the 2013 and 2015 UNGG reports. And what it says is international law is applicable, and in particular, the UN Charter. And that's it. Now, what is interesting is on the same website, the UN, you'll see in that report, it wasn't that long, but there's a compendium that was put together, and I was really glad. It's like the legislative history, if you will. First time ever, they put together, and this is 91 pages, and this is a compendium of state positions with respect to all the items in the open-ended working group final report. And not surprisingly, quite a few of the states objected to certain provisions that were in the so-called consensus report of the open-ended working group, right? It's supposed to be a consensus report, but when, and as far as the law goes, it doesn't say much. It affirms the applicability of the law and the UN Charter it mentioned specifically. It doesn't mention any of the specific principles that got into the 2015 GGE report that people were excited about if you were an international lawyer, like the general principles related to the law of armed conflict, although it doesn't mention armed conflict or LOAC or Geneva or Hague Convention. At least the 2015, the negotiators slipped in the words humanity, necessity, proportionality. But that doesn't appear in the open-ended working group most recent final report. And in the compendium of state positions, there are a number of states, the US, the Australians, New Zealand, Japan, a number of states that called this out, that they say that they wished for more, that they wished that there were other principles in the GGE that had already been agreed to that were put in. But there were also other states that said, well, we think that that was going too far. And the last part of the open-ended working group, the very last paragraph has become kind of controversial, paragraph 80, because if you read it just quickly, it doesn't seem to say much. But when you read the compendium, what the states understand it to mean while they were negotiating this was there's a phrase in that short article that says there may be a need, or we should look at other instruments to be negotiated to deal with regulating state behavior in cyber. Now, that's kind of code word for what China and Russia have been arguing, Russia since 1998, that we need a new treaty. But states like Estonia, the US, and a number of other like-minded, even Japan, New Zealand, have said that we don't need a new treaty, but that we have the laws, both treaty law and customary law, that should be and can be applicable in this space. So unfortunately, although some have described this new open-ended working group report as I've seen words like a breakthrough, something that's like amazing. Unfortunately, I don't mean to be a downer or a pessimist, but as an international lawyer, if you're looking to what breakthrough on any kind of insight into how states are thinking the international law applies, you're not going to get it, unfortunately. So I guess the jury's still out as to whether the GGE is going to be able to make progress. And talking to friends that are from different countries, the cyber diplomats in that group that are working right now, I mean, they're still trying hard, but they're kind of got this uphill battle. And they also have to contend with the fact that they've got this parallel process that's also looking at the applicability of law in this space. And they're struggling with how to come up with something that's acceptable to all parties, at least the 25 states that are in the GGE right now. Claire, how'd I do?
Excellent, perfectly timed. And yeah, with that, we can actually turn it over to question and answer. So if you do have questions, please feel free to submit them in the chat box. But in the meantime, I'm going to ask you a couple of questions. That was absolutely wonderful. Thank you so much. I really, when reading your paper, really enjoyed how you discussed both like how this activity fits into existing customary international law and this new developing area, right? Because there is some sense that we should take a technology neutral approach to the way we address this problem in international law, because this is an existing threat, right? Cyber is just the newest means of getting this done. So I would love to hear you talk a little bit more about what value you think there is in specifically making economic espionage a violation of the like cyber norms we're trying to build as well, if that makes sense.
Yeah. So here's what I learned with being part of kind of an observer in the UNGG process, right? So right now, what's happening at the UN, now there's these two processes, but for many years it was just the UNGG. That was probably the most senior and most focused area. If you asked a question, where are states debating and negotiating cyber norms, or let's put aside the word norms even, where are states kind of negotiating the rules of the road for state behavior in cyberspace? It would be within the GGE, right? Now, that's not the only place that state, like there's the cyber crime, right, convention, and there's groups of the UN, but that was the location for whatever reason. I think it wasn't even back in 2004. I don't think there was even foreknowledge of what it would become, but over time it became the place where when states wanted to try to negotiate their position, that's the place it would be. So whether it should be there or not, whether it should be in the first committee or another committee at the UN, it's there. It looks like it's staying, but now we have a counterpart, right? We have the open-ended working group. So that's why I kind of focus on it, right? So to your kind of question, going to that group and particularly watching, I guess it was like 2015 where I saw it firsthand. I was invited to Geneva, the CSIS and UN, it's UNDIR. It's one of the disarmament elements of the UN, and they do a lot of like they're supporting the UNGGE, right? It's the directorate that's supporting. They put on some workshops in Geneva, and one of the each about a week long. One of the workshops was on international law. So they invited, and the intent of the workshop was to train new members of the GGE that were coming in that hadn't, so the 2015, the GGE had been around for a while now, the membership had changed, but there are some states that were like new to this whole process, and maybe less developed states that might not have, had experience in cyber, and in fact. So they brought a number of international lawyers there. That was kind of my first experience firsthand talking and meeting with the diplomats that were representing these countries in the GGE. And so on the panel that I was on, I mean, I had the occasion, it was interesting because the questions I was talking about, the panel that I was talking about was use of force, intervention, also the due diligence principle. So, okay, and countermeasures. So an area of law that at the time I didn't realize it, but not necessarily widely agreed by these GG members. So it was Russia. It was the Russian ambassador Krutsky and also the Chinese ambassador that probably asked me the most questions. And I went back and forth. But spending a week with all of the ambassadors, talking to them, listening to what they talked about, but also understanding the restrictions as to what they were going to negotiate and what they weren't going to negotiate. Here are a few things that became clear to me, which I didn't necessarily know by just reading the open press. One, they were never going to talk about espionage in these reports. Like it was like, so it's interesting in the dialogue when I was on the panel, the Russians did bring up espionage to me because they actually brought up, and I remember specifically because it's something a case study I teach with my students, I go over it, and that was on the U-2 flights over the Soviet Union. So they obviously, this is like near and dear to their heart, obviously. They brought it up in terms of historical precedents where at the point in 1960s, early 60s, late 50s, the Soviet Union was arguing that violated their sovereignty by having U-2 flights. And this case, it culminated in the Gary Powers, shoot down and his domestic trial, domestic trial in the Soviet Union. So when they asked me that, I was very comfortable engaging that discussion about the law. But when I asked about whether that was going to be part of their negotiations, it was like, you should have seen the face on all of the diplomats. It wasn't just the Russian. It was like, yeah, no way. Right? It was like, no way. We're talking to you about this because it's kind of fun, but yeah, that is not going to be even discussed when it comes down time to sit and write a consensus draft report. Espionage is out. And so, I mean, it didn't have to be that way, right? And so I guess it was in the 2013, the 2015 report kind of was, I guess, the high point of celebration if you're into these cyber norms, because as Chris Painter, I remember he used to get all giddy about it, and I understood it. It was like his job as the cyber coordinator at the time. He pointed out, and he testified, there was specifically for the first time in the 2015 GG report, 3 very cyber specific norms that they came up with. One was, you do not conduct cyber malicious activity targeted against a critical infrastructure of another state. The other was, you do not target first responders in cyber, like CERT teams in another state. And then the third one was, if you are asked to cooperate in an investigation by, a victim state that suffered malicious intrusions, you should cooperate. So these were, it was interesting, but as you say, no mention of espionage at all. And by the 2015 timeframe when I was out there, I said, oh, okay, I get it. That's not going to happen, And even on the high level, so espionage, I think about everything on a spectrum under the law, least intrusive, most intrusive kind of idea, and espionage on the lower side, if you're just doing the collection, clandestine collection. But even on the higher side, there seemed to be a resistance, not by everyone. This is what's interesting. The US and the like-minded wanted not only to discuss, but they wanted agreement in a consensus argument, in a consensus report, that the laws of armed conflict were applicable. But it was Russia, China, Cuba in 2017, and other states that followed them that said absolutely not. And when I asked the Chinese ambassador, I got the chance when I was on that panel, he was asking me questions. So I said, oh, ambassador, if you don't mind, can I ask you a question? And I asked him, there's been a lot, in the open media reports that China's position on LOAC, Law of Armed Conflict, is that it's not applicable in cyberspace. And I said, can I ask you, for what reason? Now, not surprisingly, I should have been kind of, it's obvious the Chinese are very good at only saying what that they're supposed to say and nothing more, even if it's in a closed kind of workshop. And they gave what they'd been saying and what had been reported publicly, that they don't believe it's applicable because once you say it's applicable, you're inviting military conflict in this space. And they said, our view is that it's only for peace. And I said, okay. I said, as a matter of international law, that doesn't quite make sense if you think about the whole reason Geneva conventions came into, play. And what's ironic is it was Ambassador Krutsky that opened up the week. And I remember this because he used an American phrase. Ambassador Krutsky gets up and he says, and I also remember it is because he used a number that I hadn't seen reported in the press. He said there are over 100, so this is 2015. He said there are over 150 countries that have cyber military operations capability, or they're in the process of developing it. So I was like, oh, wow, 150. I haven't seen that quoted. And then he used an American phrase. He said, and so the cat is already out of the bag. And I said, well, okay, and I said, the Chinese ambassador, if we believe what Ambassador Krutsky said, the cat is already out of the bag, that states already have these military cyber operation capabilities and likely to be using them, wouldn't it make sense to have a set of rules like the law of armed conflict? That, and then he didn't answer, so we go on. But yeah, so I don't think from my kind of take, I don't even think we'll ever see traditional espionage discussed, never mind the economic aspect, right? Now, I wasn't so disappointed because then I saw the Obama-Xi agreement and I said, oh, that's where you're going to get it, right? All right. Well, now, as you know, there's kind of some debate as to whether, that is being complied with, but that c'est la vie when it comes to kind of these political agreements as well.
No, that's excellent. Thank you. I have a related question in the chat. So when we're looking at states being resistant to the idea of incorporating self-defense and having self-defense in the law of armed conflict be applicable, and you kind of touched on this with the Chinese ambassador's response, but what reasons do they give? Do you think it's just they want the flexibility to act how they will without recourse, or How do you characterize that?
It's interesting. So aside from taking their at face value what they say, right? They say, similar to LOAC, and so what they did not want to allow in the 2015 or the 2017 report, the 2017 report never happened, but it was a point of discussion even in 2015. They did not want to mention Article 51 or the word self-defense. Now, the like-minded, including the US, they did get slipped into that report that states have the right to conduct themselves in compliance with international law in any manner. Basically, that was a throwaway to the inherent right of self-defense. But the Russians were insistent, like, you do not write the word self-defense. Okay, so since that time frame, they've been pretty consistent with the same explanation that once you say you can take a self-defensive action, like in laws of armed conflict, once you say those laws are applicable, you're opening it up to like armed attacks and warfare in this peaceful domain. Now, that's all I had that I could point to was their words. Now, when I did at some point in my kind of work, in my academic writing, I then came into contact and met with and talked to a few former Chinese PLA that were here on, kind of in think tanks, if you will. And I met with a couple of them. And actually, one of the young women, former PLA, she reached out to me. We had coffee. And what I got from them, it was interesting. It was slightly different. It was, there is a concern, at least from their perspective, from China, that they do not have the same capabilities that the US has with respect to attribution. Now, when I don't know. I don't know what Chinese cyber attribution capabilities are at all. I have a general sense of US. Just from kind of thinking what's publicly available, that, we're pretty good. When I heard that from more than one person, I found that interesting, that that could explain why they're worried. In other words, that if they don't have the capability. Now, when I kind of turned around and talked to a couple of US government people about that, some were kind of not believing that. So I was like, oh, okay, I have no idea. But it is interesting because not completely related, but I know in in my research and at some point I became knowledgeable about when before the Treaty on Outer Space was in place, and it was during President Eisenhower's time, and President Eisenhower was advocating an open skies policy so we could all spy on each other, and therefore we wouldn't have to be worried about secrets and stuff and hiding missiles and weapons. And the Soviets, and this is like, they were always opposed to the U-2 flights. They always reserved the right to shoot down the U-2s or any spy plane in their territory. And when the satellites started going up, right, when we started putting satellites, the Soviets insisted that they violated international law. Now, US was like, no, satellites, collection from satellites. But as soon as the Soviets launched their satellites, they changed their story. And now, of course, it's like, no, satellites, yes, you can collect from satellites. So it may be about capabilities that they haven't caught up. It may be. But their answer, if you take what they say, it's because they say they don't want warfare in this space. And therefore they want self-defense out, because that's like triggering armed conflict. Yeah.
Sure. Right. Of course. But I actually have another great question here about, I'm just going to read it word for word. Do you think the US's expanding definition of national security related technologies, especially with respect to export controls, so the way we're talking about AI algorithms that may have, relatively benign uses, and our expanding control over foreign investments into the US, so with CFIUS and like the TikTok example is kind of the best example right now. Do you think that and the use of those mechanisms in any way erodes the distinction between traditional espionage and economic espionage?
So, okay, thinking about, so the export controls, as we may impose more stringent rules, in other words, or limitations on foreign ownership of US entities, does that erode the distinction between economic espionage?
I think the idea is that like we're using a much more like whole of government approach, right, to talk about IP theft and to address economic espionage, because we aren't happy with the domestic levers that we've pulled so far. It doesn't seem to really be working. So insofar as we blur the line with like export controls and just the idea that foreign companies are even able to invest in the United States, and we kind of like mix those topics. And I mean, there are so many.
I'm not an export control expert, and I have good friends that are involved in the CFIUS process. I do think you're always going to be concerned when you conflate things that there may be negative effects and consequences that you don't foresee, right? Right now, though, thinking about it generally, but I'm not talking about specific cases. I think you can still keep that distinction, in other words, but like, for instance, there may be a case where we decide, it could be a CFIUS case, where it actually has a negative impact on the distinction that we want to maintain. In other words, I could make up a fact pattern, right? I don't know though if that's actually happened, because I'm not like, I'd have to like call up a friend and say, hey, who's over at Treasury or part of the CFIUS process, have they ever had a case where they were concerned about that, right? I would think though, because the US has always maintained this distinction in policy, that, I don't always want to overestimate people being aware of things, that would be something that they would be keenly aware of, right? When they're now, I mean, I've seen things like the Wassenaar Agreement where all of a sudden you're like, wait a minute, guys, why were you doing that? Like, what were you thinking? And you wonder if they were kind of thinking about the consequences. But I can't think right now off the top of my head of a case in which that would have the negative consequences. So possible, but I don't know if practically I've seen anything yet, right?
Yeah, thank you. As a law professor, I'm sure you can make up a fact pattern. But no, so I've got one more question here, and it's a bit of a doozy, but we'll have it be the last questions. Lisa Gray is asking if you can talk about the Russian hack SolarWinds in terms of the customary international law that we've discussed today.
Yeah, so I've spoken a little bit about this. I believe I've categorized that as a pretty massive SVR a SIGINT collection operation, right? So I put it in a box of classic political military espionage, right? They, well played, sophisticated, and if anything, most of my time is spent on the side of the US saying, why did we not see this coming, right? So, similar, I had flashbacks to, the investigation of 9/11, what was going on. We had certain capabilities. We had laws that allowed our intelligence agencies to do certain things. Yes, there was some departments and agencies that had domestic authority while others only had foreign authorities, but we still had them. So why did we miss this? Similar situation, and you've seen kind of the discussions by government officials pointing out that there's a gap in the legal authorities. I do not put myself in one of those categories. I think that we have authorities to do things overseas, and then there's other government agencies that have authorities domestically. That has to do with cyber as well. But I think somewhere along the line, the US dropped the ball. But I also, I don't like giving credit to any other government's intelligence agencies, but some of our government officials do sometimes. So I'll say it. It was a quite complex SVR operation. So it wasn't kind of the run of the mill. But yeah, I put it in the box of it's espionage. So, and usually my students, why we would talk about it is when we talk about espionage, the political military, that it's not regulated under international law. So it's not prohibited. So in this case, I do say though, when I've discussed the SolarWinds, my position is that doesn't mean that you do not want to confront the Russia about this, and you do not want to take steps that you legally can against this, right? I think that's legit, because it wasn't so much that this was espionage that you would want to react. It was because of the scale and scope of it, right? So it could be legal technically, but we're talking scale and scope like never before. And you basically want to say to the Russians, like, okay, guys, you went a little too far here, right? This is not legit, and not the rule book of international law, but in the book of tradecraft of intelligence, this was way too far, right? And that's, so you do want to have that, if you will, back to the Russians, but I would categorize it as the espionage, political military.
Awesome. Well, thank you so much. We actually have just hit 1:30, so I think we've taken about as much of your time as we can ask for.
Well, thank you very much
so much for your comments today.
Claire, thank you for managing this. Good luck on all your work, on your academic work, and your work beyond school too. Thanks for having me.
Thank you. Thank you everyone for joining us.